Presiding Judge Paige Whitaker, and of course Atlanta, Georgia, apparently making progress in the racketeering trial against Jeffrey Williams, also known as Young Thug. If you're new to the case, welcome back from Mars. The rapper, along with 5 co-defendants, charged with a slew of gang-related crimes connected to the alleged street gang YSL, short for Young Slime Life. Those crimes range from drug distribution to firearms possession to armed robbery to murder. On the other side, the defense says, nope, YSL, it's just a record label, Young Stoner Life. So there are themes surrounding tough life circumstances, just part of their music. Friday marked the third motion hearing, and the jury, of course, has not been around for this. The third motion hearing this week, organized by the recently appointed judge, who's wondering what she's gotten herself into, Paige Whitaker. She's tasked with tackling all these outstanding matters left behind by former presiding judge Glanville following his recusal last month. Among other matters, several defense missed court transcripts were gathered of some prior testimony in order to argue what comes in, what doesn't, what's redacted in the case, and that's what's continuing. Remember, star witness Kenneth Lil Woody Copeland was on the stand when the trial was last in session. I think it was almost a month ago. And he was at the core of this June 10th ex parte hearing that started this whole ordeal. Copeland's testimony and police interviews were brought forth by the prosecution to further the YSL conspiracy surrounding several gang-related events throughout the past decade. So the question, what part of this testimony is going to come in? What is going to be disregarded? The court currently on a lunch break, well-deserved, I think. So while we wait for them to return, let's check out some of the action from this morning. One of the matters addressed by the parties was Copeland's police interview surrounding the shooting of YSL gang rival Donovan Thomas. This was in 2015. Check it out.
After the January 10th murder of Donovan Thomas, there were a number of retaliatory shootings. Right. One of those retaliatory shootings was on February 19, 2015, in which Mr. Copeland is coming out of his home with his daughter and his child's mother. At that time, some members of the opposition gang drive by his house, shoot at him. He shoots back at them, and he's able to find safety. Mm-hmm. He goes to the police that evening, and when he goes to the police, they ask him for the gun that he uses. Initially, in February, he tells them he'll get the gun. Mm-hmm. He'll give them the gun. He'll give them the gun. Of course, he never turns in the gun. Mm-hmm. Now in June, he is explaining to them why he did not turn in the gun. And so I wanted to give the court that context before we go into argument. The state believes it should be played. We believe that this is intrinsic to that act from February 19, that it completes that particular story in which this is now the answer as to why that gun was never turned in. And so that's the state's position, that it is, if it does places we don't think it's character, the fact that Shannon Stillwell had this gun. I believe that was the previous argument, that the fact that Shannon is a convicted felon and has a gun is bad character. We don't believe it's bad character. And if it is character, it's incidental character. But this explanation of where the gun is intrinsic to completing the story of what happened on February 19, 2021.
To the extent that the shooting on February 19, 2015, where individuals shot at Kenneth Copeland, the story, the full context, individuals allegedly drive up, shoot at Kenneth Copeland while he's holding his baby, and he's with the mother of his child. Right. He shoots back. Mm-hmm. He hits people, causes their car to crash. They're charged with this crime. Mr. Copeland's brought into the police station immediately and is questioned about things. He's never charged. Mm-hmm. Number one, if I concede that the incident itself is relevant to this case, the back and forth, that's fine. I'm willing to do that for the purposes argument. But I don't know what happened to, it's unclear to me what happened to Kenneth Copeland's gun or the gun that Kenneth Copeland fired, that is not relevant. It is no probative value to this case. My client, the fact that he is to be in possession of a gun, he's not charged for that. It's not listed as an overt act. It does place his character at issue. It's very similar to cases that he's charged with in this indictment. I believe he's charged with 2 different counts of possession of a firearm by a convicted felon. So the fact that he's charged with that exact same offense that would be implicated here increases the prejudicial value of this information. But in addition to the 401 and 403 issues involved, Your Honor, it's also based on hearsay. He's not claiming to have been there when he's saying Shannon came and got the gun. My understanding of the sequence of events, my understanding, and I'm not revealing anything my client has told me, I'm just going by what the discovery says, Shannon wasn't present. Mr. Copeland's goes to the police station. He's just been in a shootout. I don't know that he's basing any of this on firsthand knowledge. I think he's just heard this, and it's hearsay at this point. I don't think he's ever saying that I saw Shannon come in and take the gun. That's not the way I understand what he's saying. So I think there's a hearsay issue as well.
That's my reading of the transcript too. I mean, whether that's true or not, who knows? But what he seems to be saying is that when the police came by to get the gun, Shannon actually was there. And when Kenneth said, all right, let me go get the gun, by that time, Shannon had actually gone and gotten the gun himself and left the house. And so he was like, I can't get you the gun right now. Give me another day or two. So that's my understanding of it. So that would not be hearsay. So the hearsay ruling, the hearsay objection is overruled.
Okay, let me just say, if you've been following this case, and thousands of people are, even though we're not really talking about the substance of the RICO case against Young Thug and the other 5 defendants, at the end of this, I'm going to give you an honorary law degree because you learned so much about what's going on, you know, outside the presentation of evidence, outside of all of those things that we really are watching trials for, because this thing is, it's a master class in all kinds of things procedural. Some of them not good. Maddie Mangino is here, Katherine Lizardo. Hey, Katherine, let me ask you this. As I look at all of these motions being made for mistrial, the motions to dismiss with prejudice, I knew those were losers. But why not grant a mistrial? Why not just scrub the decks? Let's start this over with. There's no chance that any conviction is going to stand up on appeal, my opinion. Why not just clean this thing up?
Well, it's a tough question because this has been going on for 5 months now and counting. I think it's almost 6 months now. And a lot has been invested in this case, both the judiciary resources and the parties' resources. The jury has not been impaneled again. The jury has not been back to the courtroom since mid-June after Copeland's testimony. And and now we're on the 3rd judge of this case. And I agree with you. I think it would just be better to just start all over again and maybe have a case management order, something that would make this case be more streamlined because of the unique RICO case that it is, with how complex that it has become. I don't see the light at the end of the tunnel at this time. I honestly feel we're starting over again with this new judge.
Yeah, she's definitely getting an education, whether she likes it or not. Maddie, you know, those on the defense side that want not just a mistrial, they want a dismissal with prejudice. Their argument is, we're into this thing already. Double jeopardy is attached. You can't just, you know, start over and give the defendants another try. They've been here. They've been taking part in their own trial. You can't hold against them the fact the system and maybe the judge just messed this whole thing up.
Well, yeah, Michael, as you pointed out, I mean, you know, the viewers have been watching this. They have seen the good, the bad, and the ugly about the criminal justice system in this case. I mean, lapse, the ethical lapse by the judge to listen to ex parte arguments and have ex parte discussions on more than one occasion, we know, with prosecutors, is really, really beyond the pale, frankly, from my point of view. I definitely believe that a mistrial should be granted, that a new trial should be commenced, because it's not like, hey, look, we got all this time and money that we spent on this case so far. Let's keep it going. You're going to try this case again no matter what, because the appellate courts are going to send this case back if there's a guilty verdict and say, listen, you should have started over a long time ago, but now you're going to start over for sure. I don't think the case should be dismissed with prejudice. You know, mistrials happen all the time, and it's not a double jeopardy issue. But I think this case should begin again.
Yep, and there's still some motions on the table there. I know, Katherine, I think you mentioned it had been going for 5 months. It's actually closer to 9. I know what you're counting. You're counting actual time in court, in session. Because you may remember Judge Glanville had, let's just say, a little tighter schedule, not so expansive. This judge, boy, she's out of her mind. 8 to 6 every day. Oh, my gosh, they might actually get something done. So we're going to take a break. We're going to come back and see what else they're getting done today. Again, no jury in the case against Young Thug. They'll be back next week. I can only hope they're all going to show up. We'll be right back.